Islamic law is not the supreme law of the federation because the federal constitution has clearly stated that the supreme law of the country is the constitution itself. The Islamic law only has effect on limited matters such as matrimonial issues and other limited criminal jurisdiction. The provision that I would like to mention here is the Article 1211A of the Constitution Amendment Act 1992. In this provision, it is stated that the courts referred to the Clause 1 shall have no jurisdiction in respect of any matter within the jurisdiction of the Sharia courts. One of the objectives of this provision is to prevent conflicting jurisdiction between the civil courts and the Sharia courts, especially when civil courts interfere or overrule the jurisdiction in Sharia courts. For example, the conflict that arises here can be shown in the case of Ainan bin Mahmud and Sheikh Abu Bakr, where there is conflict between the decisions made by civil court and the Sharia court on the matter regarding the legitimacy of child. However, after the amendment of Article 121 of the Federal Constitution, the effect of the amendment is that Sharia court has exclusive jurisdiction, whereby the civil court cannot interfere with its jurisdiction. For example, in the case of Nukrusia Baharuddin and Sharul Lamin, the High Court held that it has no jurisdiction in matters relating to Muslims party in custodianship. However, a problem arises here is that in a family dispute case between the Muslims and the non-Muslims, which court should have jurisdiction? This issue was solved in the case of Subashi, A.P. Rajasingam and Saravana, as the federal court held that the High Court should have exclusive jurisdiction in matters which involve divorce and custody rights of couple when only one of the spouses is Muslims. In conclusion, the amendment made to Article 121 can ensure that the decisions made by Sharia court are not interfered by the civil courts, therefore preventing conflict of jurisdiction between Sharia court and the civil court.